All rise. Ms. Court, please back in session.
Okay, please be seated. Okay, we're back on the record in State versus Madden, CR 22-121675. The jurors are not present at this time. Counsel for the state, Mr. Burris and Mr. Hahn are present, along with Detective Horton, and Mr. Madden appears in person with counsel, Mr. Wilder. Just a few housekeeping details before we get started today. Counsel should have found on their table a packet of the jury instructions. Those are draft instructions. I don't expect you to comment on those today. I just wanted to give you a working copy so that as we go through the evidence in this case, you're able to make comments and request additions or corrections to those. The other thing I wanted to bring attention is we do have the media covering the trial. I have instructed that the jurors will not be filmed. I would ask the counsel to police their own witnesses. If any of your witnesses do not wish to be on film, please let me know that prior to the witness taking the stand, and I will instruct the camera operators to not film that particular witness. Okay, so are we prepared to go forward, Mr. Burris?
With opening, yes. I know Michaela Madden, who has been the victim rep for most of this, is the daughter of the defendant and daughter of the deceased. I do believe wishes to exercise her martial law rights and be present for whatever part of the trial that she would be allowed to.
All right. Then, do you have any comment on that, Mr. Wilder?
Yeah, we would object to that.
Listen, I don't want to object to anything. I just want to. This is about the family that I love. And listen, I'm responsible for what happened to her. I didn't mean get into it.
Judge, are we recording?
I believe we are.
And I'm so
We need to take a recess?
Yes.
Okay, let's take a recess and
I
we'll
love you. And
go
I
on.
don't want you to hate me. I don't want you to hate me.
rise. Ms. Court, please back in session.
Okay, please be seated. Okay, we're back on the record in State versus Madden, CR 22-121675. The jurors are not present at this time. Counsel for the state, Mr. Burris and Mr. Hahn are present, along with Detective Horton, and Mr. Madden appears in person with counsel, Mr. Wilder. Just a few housekeeping details before we get started today. Counsel should have found on their table a packet of the jury instructions. Those are draft instructions. I don't expect you to comment on those today. I just wanted to give you a working copy so that as we go through the evidence in this case, you're able to make comments and request additions or corrections to those. The other thing I wanted to bring attention is we do have the media covering the trial. I have instructed that the jurors will not be filmed. I would ask the counsel to police their own witnesses. If any of your witnesses do not wish to be on film, please let me know that prior to the witness taking the stand, and I will instruct the camera operators to not film that particular witness. Okay, so are we prepared to go forward, Mr. Burris?
With opening, yes. I know Michaela Madden, who has been the victim rep for most of this, is the daughter of the defendant and daughter of the deceased. I do believe wishes to exercise her martial law rights and be present for whatever part of the trial that she would be allowed to.
All right. Then, do you have any comment on that, Mr. Wilder?
Yeah, we would object to that.
Listen, I don't want to object to anything. I want to, this is about the family that I love. And, listen, I'm responsible for what happened to her. I didn't mean it.
Court, please back in session.
Please be seated. We're back on the record in State versus Madden. Again, the jurors are not present on behalf of the state. Our assistant prosecutors, Brad Burris and Michael Hahn, and Detective Horton is also present. In addition, Mr. Madden is present with his counsel, Mr. Wilder. Mr. Wilder, is there any need, do we need to address anything before the jurors are brought in?
Yes, I do believe we should, Your Honor, given what just occurred in court. I'm a little concerned about Mr. Madden's emotional state on seeing some of his family members, and at the chance that may repeat itself in front of the jury, I certainly don't want anything like that to be prejudicial to his defense or his case or his interests. So I do believe at this time, Mr. Madden, because of those reasons, the emotion of this and his family being here, I think he is preferring to be somewhere else in the courtroom, the courthouse, to watch by video, because I don't believe he can get through the portion of this, especially the beginning, without having the emotion he just displayed in court just a few moments ago.
Okay, Mr. Madden, you've heard Mr. Wilder's representation. Is that your, as what he expressed to the court, how you desire to proceed today?
Yes, ma'am.
All right. And
Yes, ma'am. For having seen, look at haven't seen my family, and now I'm hurt. I'm
just move that up. Yeah.
Right. Well, it appears that you have regained your composure, and I do want you to have a fair trial and to be able to participate with your counsel in your defense. We've gone over a number of cases in the past talking about disruptions in the courtroom. Those include Illinois versus Allen, 90 Supreme Court, 1057, and out of our Court of Appeals in the 12th District, State versus Cook, 2021 Ohio, 2157, and State versus Kilgore, 2006 Ohio, 2139. And as I indicated to you previously, we must have decorum in this courtroom and proceed without disruption. But I want to give you the opportunity to be here, but I can't let you disrupt the proceedings. So I'm going to give you one final caution and ask that you keep the decorum that these proceedings require. And if you fail to do that, I will have you removed from the courtroom, and we will take you to another room where you can view the trial on television, but you will not be in the courtroom so that we can proceed with these matters. Mr. Burris, is there anything that you wish to put on the record at this time?
I'm in agreement with the court. I was just going to say, I don't think he's had an outburst yet in front of the jury that warrants removal at this point.
Very well. Okay. And is there anything that you wanted to put on the record before we bring the jurors in?
The statement was made in front of defense counsel. I do feel like I probably have to supplement discovery in some way, so I will make an oral supplemental motion as to the statements that Mr. Madden made to family members and in front of the media. It's not actually some of them were from the court as well, that's on record. And then I will do a written supplemental discovery later on today when we get down to tomorrow night. I don't want to use the word prejudice, but obviously Mr. Wilder was right next to him, so he would have heard all the statements.
We stopped the proceedings after you had raised the issue of the victim's representative being in the courtroom and exercising her constitutional rights under Marcy's Law. You heard the objection. Did you have any response that you wish to offer with regards to that?
No, thank you.
All right. At this time, I am going to permit the victim's representative to remain in the courtroom. Is there an expectation that that representative will be testifying at some point during the trial?
I believe she'll be the first one to show up.
All right. Okay. And the court will find then that there will be little to no prejudice given that the witness will be the first witness to testify. But if we need to revisit that issue, we certainly can do that. Okay. Anything else before, or do we need a few minutes before we start with opening statements?
Mr. Hahn's going to do the opening statement. I believe he's good to go.
Okay. All right. Let's go ahead and bring the jurors in.
Judge, I'm sorry.
Oh, just a minute.
I would make a motion for separation of witnesses. I don't know if you want to do that now or
Sure,
after
let's go ahead and
opening,
do
but I would, the defense would move to separate all witnesses in this case so no one's able to hear the testimony of the other before they're called to the stand.
Okay. And Mr. Burris, on that issue, I've already ruled that the victim's representative may remain in the courtroom. Are there any other witnesses in the courtroom that you anticipate will testify?
Not on behalf of the state of Ohio, however, I do believe Mr. Wilder has at least verbally indicated to me you might be calling Miss Celeste. She is in the courtroom.
Well, she's on your list too.
Yeah, but I'm not intending on calling her, but I'm not playing games with you now. I'm just saying, she is in the courtroom, and you did verbally indicate to me that you may call her as a witness. So that's the one for you. That's one for you to address.
And just so the record's clear, that was on the list that the prosecutor gave me through email. Her name was on that list.
All right.
I don't know if I will call her or not, so I would consider her a defense witness at this point and ask her to leave the courtroom.
All right. Very well. Thank you.
And I would also reiterate, I'm asking for my client to be addressed, because I don't think he should be in this courtroom in front of this jury the way he's acting right now. I think it's prejudicial to him to do this in front of a jury. So I'm asking for him to be addressed on whether his appearance, he will waive it and go upstairs, because I think it would impact his defense in this case.
All right. And again, I will rely on the cases that I previously cited, and I'm going to proceed with caution on this issue so as to give Mr. Madden the fair trial that he deserves. And that we will have to see where things go, but I hope that he'll be able to remain collected and assist in his defense. With regard to separation of witnesses, I will grant that motion, again permitting the victim's representative to remain in the courtroom as well as Detective Horton, who is the state's designee. Okay, so with that, anyone that, other than those two individuals that expects to testify in this trial will need to leave the courtroom, and we can bring the jurors in at this time.
Judge, he's indicated he does not want to be in here.
All right.
I understand.
I've made my ruling, and I'm going to stand by that at this time. Please be seated. I want to start by thanking you for your patience, ladies and gentlemen. It's not our practice to delay the proceedings, but sometimes things happen that necessitate that. I will assure you that we have been working diligently outside of your presence, and again, I appreciate your patience. So at this time, I'm going to give you some opening instructions, and before we hear the opening statements of counsel and begin to take evidence, it may be helpful if you have some preliminary instructions to help you follow in listening to and considering the evidence. Later, after you have heard all of the evidence and the closing arguments of counsel, I will give you further instructions on the law. It is the duty of the judge to instruct you on the law, and it is your duty to follow the law as I will state it to you now and from time to time during the trial and at the conclusion of the final arguments. You, the jury, have the exclusive duty to decide all questions of fact submitted to you. In connection with this duty, you must determine the effect and the value of the evidence. You must not be influenced in your decision by sympathy, prejudice, or passion toward any party, witness, or attorney in this case. If in these instructions or in the instructions I may give you later, any principle or idea is repeated or stated in different ways, no emphasis is intended and you shall infer none. You must not single out any particular instruction and ignore others. You are to consider all of the instructions as a whole and are to consider each instruction in relation to the other instructions. The fact that I give you some instructions now, others during the course of the trial, and further instructions after final arguments has no significance as to their relative importance, nor does the order in which I give you the instructions. In the event you should experience a personal problem during the course of the trial, you may explain the matter to Mr. Housekeeping, and the message will be relayed to me. The attorneys for the parties will, of course, have active roles in the trial. They will make opening statements, question witnesses, make objections, and finally will argue the case as the last step before you hear my final instructions and commence your deliberations. Remember at all times that the lawyers are not witnesses, and since it is your duty to decide the case solely on the evidence you see or hear in this case, you must not consider as evidence any statement of any attorney made during the trial. There is an exception, and that is if the attorneys agree as to any fact. That agreement, stipulation, or admission of fact will be brought to your attention, and you may then regard that fact as being conclusively proved without the necessity of further evidence on that fact. During the course of the trial, the court may instruct you to disregard certain statements of a witness or of counsel. This may be a difficult concept for some jurors. The court does not anticipate that you will literally forget or delete from your minds the matter that you have actually heard. The instruction means that if or when you remember anything that you have been instructed to disregard, you must say to yourself, I cannot consider or be influenced by that in any way or for any purpose. Obviously, the forbidden matter must not be mentioned or otherwise be a part of your deliberations. If a question is asked and an objection to the question is sustained, you will not hear the answer. You must not speculate as to what the answer might have been or as to the reason for the objection. If an answer is given to a question and the court then grants a motion to strike the answer, you are to completely disregard that question and the answer. You will not consider them for any purpose. A question in and of itself is not evidence and may be considered by you only as it supplies meaning to the answer. When an objection is made, it does not mean that someone is trying to conceal some evidence from you. There are rules governing the admissibility of evidence which must be followed, and the court attempts to accomplish this by ruling on the objections. The objection is made to call the court's attention to a perceived transgression of the rules. Over the centuries, the law has determined what evidence is reliable and what evidence is not reliable. In order to preserve the integrity of the trial, each side attempts to ensure that only reliable evidence is presented to the jury. This is usually the reason for an objection. There will be occasions when the attorneys approach the bench and speak to the court out of your hearing. You must not speculate as to these discussions which concern points of law, because they are not evidence, and it would be unfair to all parties before the court for the jury to consider these discussions, which are not part of the evidence upon which you will base your decision. As jurors, you also have the sole and exclusive duty to decide the credibility of the witnesses who will testify in this case. This simply means that it is you, the jury, who must decide whether to believe or disbelieve a particular witness. In making this determination, you will apply the tests of truthfulness which apply in your daily lives. There are several tests of truthfulness, one of which is the bias or interest, if any, of a witness. That is, if a witness has a personal, philosophical, or financial interest in the outcome of a case, that fact shall be considered in determining the weight to be given to that witness's testimony. Other tests of truthfulness which you shall consider include the appearance of each witness upon the stand, his or her manner of testifying, the intelligence of the witness, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which he or she testified, his or her accuracy of memory, frankness or lack of it, together with all the facts and circumstances surrounding the testimony. Apply these tests and assign to each witness's testimony the weight you deem proper. You are not required to believe the testimony of any witness simply because it was given under oath. You may believe or disbelieve all or any part of the testimony of any witness. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of that issue. Rather, the final test in judging the evidence should be the force and the weight of the evidence, regardless of the number of witnesses on each side of an issue. The testimony of one witness, believed by you, is sufficient to prove any fact. If there are discrepancies in a witness's testimony or between any witness's testimony and the testimony of other witnesses, this does not necessarily mean that you should disbelieve the witness, as people commonly forget facts or recollect them differently after the passage of time. You are all certainly aware that two persons who are witnesses to an event may see or hear it differently. In considering a discrepancy in a witness's testimony, you should consider whether that discrepancy concerns an important fact or a trivial one. Should you, in the course of your deliberations, conclude that any witness has intentionally testified falsely to a material fact, you are free to disregard all of that witness's testimony on the principle that one who testifies falsely as to one material fact may also testify falsely as to other facts. You are not required, however, in all circumstances to consider such a witness unworthy of belief. You may accept so much of that witness's testimony as you believe to be true and reject only that portion which you conclude is false. Now, you should have notebooks in hand. Okay, I want to talk with you about note-taking. During this trial, I will permit you to take notes, and the court has provided you with pencils and notepaper for your convenience. For many years, the practice of juror note-taking was discouraged because the taking of notes distracts your mind from the evidence that is presented while you are busy taking notes. The other reason was that the best note-taker might have more influence on other jurors than is wanted. Remember, each of you must individually determine the issues in this case. It is your responsibility to observe the witnesses as they testify and to listen attentively to all the testimony. At the end of the case and deliberations, your collective minds will then reach a verdict. The notes are only to be used as a memory aid and should not be allowed to take precedence over jurors' independent memories of facts. Please understand that testimony cannot be repeated nor the trial delayed to permit the taking of accurate notes. It is your responsibility to observe the witnesses and to listen to the testimony. There is no requirement that you take notes. Okay, at this time we are going to hear the opening statements. And the opening statements of counsel are concise and orderly descriptions of each side's claims and defenses and the evidence counsel expects to produce in support of those claims and defenses. They are previews of the respective cases designed to give you some perspective on the evidence. Opening statements are not evidence. Each side may address you once during opening statements, and in accordance with the rules that govern these proceedings, the state will speak first. Okay, on behalf of the state.
Thank you, Your Honor.
Good afternoon, ladies and gentlemen. As you can see here, I have an opening statement prepared. However, sometimes things happen where you have to change on the fly. So I'm still going to give you this opening statement. However, I'm going to tell you something first up front. So probably 30 minutes ago from now, you all were back in the jury room. Mr. Madden was brought into the courtroom here. The record was on. We had to deal with some preliminary matters before you were all brought in. Mr. Madden saw Michaela Madden in the back of the courtroom, and the rest of family members. And he turned to them and said, as he made a motion of this, I'm responsible for what happened to her. I didn't mean it. I love you. That was recorded, and you're going to hear that recording during this trial. You're also going to hear from witnesses that also heard it. Detective Horton heard it. He was sitting here. Michaela heard it. She was sitting there. He was talking right to her. So you're going to hear that in this trial. And now, my plan is to give my opening statement that I did have prepared and explain to you what he didn't mean to do. And ladies and gentlemen, it's 55. That's the number that I want all of you to remember. You're going to hear that number a lot throughout this trial. And that's because that's the number of times that Toby Madden, that man sitting right there, stabbed Rachelle Brewsaugh on October 11th of 2022 and killed her. 55. He stabbed his girlfriend of over 20 years and the mother of his child 55 times. And because of this stabbing, he was charged and indicted on 4 counts. And I think it's important, I know you heard it already from the judge in voir dire, but I think it's important that you hear the indictment, and I'm going to read it to you. And I think it's important because I want you to understand these charges, and I want all of you to understand the elements that the state's going to prove to you throughout this trial. Count 1, murder. On or about October 11th of 2022 in Butler County, Ohio, Toby L. Madden did purposely cause the death of Rachelle Brewsaugh, which constitutes the offense of murder, an unclassified felony in violation of Revised Code 290302 and against the peace and dignity of the state of Ohio. Count 2, murder. On or about October 11th, 2022, in Butler County, Ohio, Toby L. Madden did cause the death of Rachelle Brewsaugh as a proximate result of the offenders committing or attempting to commit an offense of violence that is a felony of the first or second degree and that is not a violation of Section 290303 or 290304 of the Revised Code, which constitutes the offense of murder, unclassified felony in violation of 290302B. Count 3, felonious assault. And then in parentheses, serious physical harm. On or about October 11th of 2022, in Butler County, Ohio, Toby L. Madden did knowingly cause serious physical harm to Rachelle Brewsaugh, which constitutes the offense of felonious assault, serious physical harm, a second-degree felony in violation of 2903.11a1. And finally, count 4, felonious assault with a deadly weapon. On or about October 11th of 2022, in Butler County, Ohio, Toby L. Madden did knowingly cause or attempt to cause physical harm to Rachelle Brewsaugh by means of a deadly weapon or dangerous ordinance, which constitutes the offense of felonious assault with a deadly weapon, second-degree felony in violation of 2903.11a2. That's what he's been charged with for what happened on October 11th of 2022. So I'm going to take you back to that time. On October 11th of 2022, Toby Madden and Rachelle Brewsaugh were living in a house at 1270 Parish Avenue in the city of Hamilton, Butler County, Ohio. They were living there and they were renovating that residence at the same time. And on October 11th of 2022, Rachelle had called the city of Hamilton, the utilities department, and asked that the gas be turned on because they didn't have any gas service there. So at 8 a.m. on October 11th of 2022, 4 City of Hamilton utility workers came out to the residence at 1270. And you're going to hear from all 4 of them. They're going to explain to you how they went up to the door, knocked at 8 a.m. She answered. She let them in. She had a big dog. They had a big dog in this residence. She showed them the way to the basement. They needed to go see the furnace and do some work on the furnace. So she showed them the way to the basement, and she sat on the couch near the front door holding the dog so the dog wouldn't bother them. And as they go downstairs into the basement, they go through an adjacent room right next to where she's sitting on the couch with the dog. And these city workers are going to tell you that there was a male in a chair covered by a blanket, and he was sitting there sleeping. And he didn't get up. He was just there. He didn't say anything to him. So they go downstairs into the basement, and they run their tests on the gas lines, but apparently there's something wrong with the furnace. The furnace doesn't work, so they cannot turn on the gas. So around 8:30 a.m., they go back upstairs out of the basement. They tell Rachelle, the male's still sleeping in the chair. I believe he tells one of the workers, like, what's up, or something to that effect. They walk past him. They go into that front room with Rachelle sitting there with the dog, and they tell her, I'm sorry, we can't turn the gas on to your house. The furnace is broken, and you need to get the furnace fixed first. And they leave at about 8:30 a.m., all 4 of them. And they're all 4 going to tell you that they saw Rachelle as they left, and she was alive and well. And that the house, furniture is not in any disarray. The furniture that is in there is in its correct place. So the next thing you're going to hear, then is at noon, so 3.5 hours later, Hamilton Police Department gets a 911 call. And they respond out because Rachelle's been stabbed and killed. So you're going to hear from first responders, Officer Katie Johnson and Officer Taras Volchikov, who at the time was with Hamilton PD in 2022. He's no longer with HPD. He's now with Warren County. But you're going to hear from she's a detective now, but Officer Johnson at the time, you're going to hear from her, and she's going to tell you how that when she arrives, she goes into the house, and there's Toby Madden on top of Rachelle trying to do CPR on what is clearly a deceased person. She pulls him off, gets him outside, hands him off to Officer Volchikov, who takes him outside to the sidewalk. And what else? The other thing that Officer Johnson's going to tell you is that when she goes through that house, there is absolutely no signs of forced entry by anyone. Doors are locked, back doors locked. You're going to see these pictures. There's no breaks in the door jamb in the front door. Windows are intact. And Officer Volchikov is going to tell you that, yes, he was acting hysterically inside when Officer Johnson went in there and pulled him off. But as he gets Toby Madden outside on the sidewalk, Toby then asks for a cigarette. And then wants to go back inside because he says he needs to get his jacket and his wallet. Of course, Officer Volchikov doesn't allow this, and Toby gets mad at Officer Volchikov for that. The next thing you're going to hear is you're going to hear from Ann Mayers. Ann Mayers is a neighbor who lived at 1260 Parish Avenue, which is right next door, and these houses are close together. She's going to testify, and she's going to tell you that she was sitting on her porch in the morning around 9 a.m., between 9 and 9:30, and she sat out there every morning with her sister that she lived with and drank her coffee. This morning was a little different on October 11th. She heard a scream, and she said that she's going to tell you that it comes from the direction of 1270, so her left, as she's sitting on the porch. But she's also going to tell you that At that time, on October 11th of 2022, she was 73 years old. And she wore hearing aids, and she didn't have them in that morning. But she still heard the scream, but she wasn't exactly sure what it was. She's going to tell you she didn't know if it was a woman screaming or if it were kids playing in the neighborhood. So she didn't do anything about it. She went inside, and she's going to tell you that she went inside and ate breakfast. But then when she comes back outside after breakfast, she's going to tell you that now there's police activity in there, out in the yard and in the street, because she didn't come back out for a while. And she watched all that police activity, and she heard Toby Madden tell police officers out in the yard that there were 3 city workers that came into my house. You're also going to hear from Michaela, Rachelle's daughter, Toby's daughter. She's going to tell you about her parents' relationship. She's going to tell you how they moved from place to place over the years. She's going to tell you about the on-again and off-again nature of their relationship and the bumpy relationship. She's going to also tell you, as I said before, what he just said to her right here in this courtroom while the record was running. You're also going to hear from Detective Aaron Huckey. He works with the Hamilton Police Department. He's going to testify and tell you that he arrived at the scene on October 11th of 2022. And the first thing that he noticed when he went into that house at 1270 Parish is he's going to tell you how he's hit with the smell of rubbing alcohol. And then he's going to explain to you how he goes through that house and he takes pictures, inside and outside. And you're going to see all these pictures for yourself. And you're going to see in these pictures that there is no forced entry. You're going to see in these pictures that there was clearly a struggle inside of this house at 1270 Parish. There's going to be an entertainment center overturned, other furniture pushed around, out of place. And you're going to see the pictures of Rachelle's body laying on the floor, deceased, with 55 stab wounds in her body. And the blood that is all over the wall and the window and the floor. Then you're going to hear from Dr. Russell Updegrove, who performed the autopsy on Rachelle's body. He's going to explain to you how he performs an autopsy and how he performed the autopsy on her body. And he's going to guide you through the pictures of the autopsy. And you're going to see in those pictures the stab wounds that are in her legs, that are in her arms, in her back, in her torso, and in her head. And then he's going to go through the pictures of the piercing wounds through her liver, through her lungs, and through her heart that all came from 55 stab wounds. Then you're going to hear from Detective Robert Horton. He's the leading investigator in this case. And he's going to tell you that on October 11th of 2022, that he interviewed Toby Madden. And that Toby Madden implied to him that 3 utility workers from the city of Hamilton did this. They killed Rachelle. And he's also going to tell you that Toby Madden told him in that interview that people were out to get him. And then he follows that up with, but he doesn't know anyone that would want to hurt Rachelle. And Detective Horton is going to tell you how he photographed Toby Madden. Photographed scratches on his arms, on his torso, and on his chest. He's going to tell you that on October 11th at the scene, that he collected a black backpack at the scene that contained a red-handled Swiss Army knife. And that Swiss Army knife appeared to be wet. And he's going to tell you how he went to Rachelle's autopsy. And he collected the black Planet Fitness t-shirt that she was wearing when she was murdered. And you're going to see the holes in that shirt. And he's also going to tell you that he collected a sample of her DNA when he went to that autopsy. And then he's going to tell you that about 2 weeks after the murder, he discovers that Toby Madden went to Kroger the night before the murder on October 10th. And he went to the Kroger on Route 4 and Grand Boulevard in the city of Hamilton. And that's very, very close to 1270 Parish. And he's going to tell you that he pulls video from Kroger. And you'll see the video, and you'll see the still shots from it. And Detective Horton takes note of what Toby Madden is wearing in that video. He's got on a green vest and a gray shirt. And he purchases some candy bars and miscellaneous items. And Detective Horton is then going to tell you how because of that video and those clothes that he was wearing on October 10th, he obtains a search warrant, goes back into 1270 Parish, and then he finds that green vest and that gray shirt in the basement and finds that Kroger bag. And when he finds that green vest and gray shirt, he sees blood on it. And these are different from the clothes that Toby Madden was wearing when the police showed up on October 11th. Because you'll see in the pictures, he has on a bright, yellowish, neon-colored shirt. And then the next thing you're going to hear is from Detective Doug Trenum. Detective Trenum went in on October 11th into 1270 Parish, and he saw blood stains in the bathroom sink. They were visible to the naked eye, and he collected those blood samples. And he's also going to tell you that there were blood stains and blood in that sink that wasn't visible to the naked eye. And he's going to explain to you how he figured that out and how he found those. And he collected those samples of that blood. He's also going to explain to you that 2 weeks later, after Detective Horton finds these clothes, Detective Trenum takes blood samples off of the green vest and the gray shirt. And he sends all of those samples up to the Bureau of Criminal Investigation in London, Ohio. Now, you'll probably hear all of us refer to that as BCI, but that is the Bureau of Criminal Investigation. And finally, ladies and gentlemen, you're going to hear from Catherine Daly from BCI. And she's going to come down here and she's going to tell you, she's a forensic scientist, and that she tested all of these samples that were sent to them from the Hamilton Police Department. And what she's going to tell you is that Rachelle's blood is in that sink. Rachelle's blood is on that green vest. Rachelle's blood's on that gray shirt. Ladies and gentlemen, every trial is like a puzzle. When you build a puzzle, and in that trial, every witness that you hear from, they're giving you pieces to that puzzle. Every exhibit that you're going to see is giving you pieces to that puzzle. And as you all know, when you do a puzzle as a kid or whoever does them even still now, when you're putting that puzzle together, you figure out what the picture is even before you get all the pieces. And throughout this trial, you're going to get those pieces. And you're going to see that that puzzle reveals Toby Madden. And we're going to stand back up here and we're going to ask you to find him guilty on all 4 counts. Thank you.
Thank you, Mr. Hahn. Mr. Wilder, do you wish to make an opening statement at this time?
Judge, may we have a quick sidebar?
Sure. Okay, Mr. Wilder.
Yes, Judge, for reasons just stated in the sidebar, which I won't go into now, the defense at this time is not making an opening statement, but we reserve the right to make that opening statement during our case in chief.
Very well.
Thank you.
All right, could the state please call its first witness?
Yes, Your Honor, the state will have call Michaela Madden, please.
Okay, you may proceed, Mr. Burris.
Or would the court like to put it in?
Wherever's comfortable for you is fine. Are all of the jurors able to see the witness stand with the podium there? Okay, that'll be fine.
Good afternoon, young lady. Would you please state your name for the record and spell your first and last name, please?
Michaela Madden. It's MC capital K AYLA. Last name Madden MADDEN.
And I apologize, Your Honor. I forgot to ask Miss Madden. I know there's recording going on, TV recording.
Ma'am, these proceedings are being filmed. Do you have any objection to being filmed?
Thank you, Judge. I apologize. And Miss Madden, what part of town do you currently live in?
Westchester, Ohio.
And I'm going to give you a few names if you can tell me how it is that you know these individuals. Do you know a person by the name of Rachelle Brewsaugh?
Yes, she's my mother.
Okay. And do you know an individual by the name of Toby Madden?
Yes, my
Okay.
father.
Okay. Do you see Toby Madden in the courtroom today? If you could please point to him and describe for the ladies and gentlemen of the jury what it is he's wearing.
He's wearing a plaid shirt and khakis.
Okay, Your Honor, I'd ask the record to reflect the witness as identified, the defendant Toby Madden.
The record will so reflect.
And ma'am, how old are you right now?
I'm 26.
Okay. And are your parents married?
No,
Are they boyfriend and girlfriend?
I guess you can say.
Okay. Do you know how long they have been in a relationship?
Probably 28 years.
Okay. Probably ever since you were around the time
Yeah,
you were born and
before
leading up
me.
to that? Okay.
Too.
And you were here in the courtroom before the jury came out, weren't you?
Yes,
Okay. Where were you seated?
over in the corner right there.
Okay, were you seated in probably the
Third row.
third row? And whereabouts were you seated?
By the window.
Okay. Did you see your father, Toby Madden, walk into the courtroom?
Yes.
Okay. At some point, did you hear Toby Madden say something to you?
Yes.
Or say something really in front of a lot of people?
Yes, in front of
Okay.
everyone.
Okay. The detective was there?
Yes.
The media was there?
Yes.
Okay. What did you hear your dad say to you?
I'm sorry. We got into an altercation, and I basically am the one that did it. Basically, found it guilty. I love you. Don't hate me.
On October 11th, 2022, the day that your mother was allegedly stabbed several times at this point, where was your mother living?
Parish Avenue.
Okay. If I told you the address was 1270 Parish Avenue, does that sound about right?
Yes, Your Honor. Yes.
Yes. Is that located in the city of Hamilton, Butler County, Ohio?
Mm-hmm.
Okay. And I know it's a couple years ago now, so if you don't know, it's okay. Do you know about how long your mom had been living at that address?
Not for long. She was trying to basically renovate it, get it up to date.
Do you know how it is that your mom started living there, or who helped her
My
get that house?
my aunt Sherry, she helped get establish the housing to get her somewhere where she could be stable.
Do you know when Rachelle initially moved into that residence, did anybody move in with her, do you know?
No, not really. It was supposed to just be for her.
Okay. Did your mom have a dog?
Yes.
Okay. Can you describe, do you know what kind of dog that your mom had?
A big fat bulldog pit bull,
Okay.
gray and white.
When you say big, how big?
Oh, fat. Very fat. Wide too.
Like over 100 pounds big?
He's probably 80. Probably 80.
Okay. Had you ever been over to that house at 1270 Parish?
Yes.
Okay. How many times would you say that you've been there?
Quite a few times to see the progress.
Okay. What was going on inside of the residence?
The flooring was being replaced. Basically, she was working on that. New cabinets were coming in. She's getting some furniture in the house.
At some point, did you become aware that your father, Toby, sort of moved into that house?
Yes.
Do you know in relation to when it is, I'm sorry, strike that, let me ask it this way. Do you know how long that your mother had been living at that house on 1270 Parish before your dad moved in?
Probably the end of September.
Okay. So Toby did not move in right away?
No.
Okay. And actually, if I can approach the windshield.
You may.
And I apologize. If I may approach with you. I'm showing defense counsel what's been marked as State's Exhibit 4. I may approach you with
You may.
You recognize what's in State's Exhibit number 4?
Yes.
Okay. What is in State's Exhibit number 4?
The parish house that she was living in.
Okay. Does that photograph truly, fairly, and accurately depict
Yes.
the residence?
Yes.
Your Honor, I'd ask for permission to publish to the jury.
Any objection, Mr. Wilder?
No objection.
All right, permission is granted.
Do you want it up here?
I think is it going to go on the... What do I need to do?
Using your computer or
I was going to use the computer. Sorry. Should I use Elmo?
no?
It's on our screen.
All right, it should be on the screen in front of you as well. What are we looking at in State's Exhibit number 4?
The Parish Avenue house.
Okay. That's a house that your mom I'm sorry, that your aunt was renting or kind of on a land contract for your mom?
Land contract.
On October 11th, 2022, you can take that if you need to. Was your mom working somewhere?
Yeah.
Where was she working?
It was Magnolia Groves in Loveland, Ohio.
Okay. And what was her job there?
She was a nurse.
Prior to your mom moving into 1270 Parish Avenue, do you know where your mom was living?
She was staying with my cousin for a while. Ginger Halcomb.
Okay. At some point, was your mom living down in Covington?
Yes.
Okay, do you know the time frame of when your mom was living in Covington?
It would have to be, sorry, my brain, probably around, I want to say June 2022.
Okay. Do you know how long she had lived down in Covington?
Not for long.
Okay. Who was she living down in Covington with?
Toby.
Your dad?
Mhm.
Okay. Have you ever been down to Covington to see
Yes.
your mom and your dad?
Yes.
Okay. Did you ever hear your dad have an argument with Rachelle regarding her not being faithful?
Yes.
Tell us about that if you would, please.
Many times he would accuse of her of cheating or being a prostitute, but she was not.
Did you and your mom live together at some point prior to Covington?
Yeah.
Where did you guys live?
Athens in Loveland, Ohio, a townhome.
Townhome? Why did you get, I'm sorry, who was the first one that got that townhome?
Me and my mom.
Okay. Was there anybody else that was living with you there?
My daughter's father.
Okay. Were your daughters living there as well? I'm sorry, your
Yeah,
daughter?
yeah.
At some point, did Toby move into that apartment or that townhome?
Yes.
I assume you weren't too happy about that?
No.
Safe to say your mom and dad had an on and off again relationship over the years?
Very.
I think I just have two more pictures.
All right.
I'm showing defense counsel what's been marked as State's Exhibit 110. I may approach a witness, Your Honor.
You may.
State's Exhibit 110, do you recognize what is depicted in State's Exhibit 110?
Yes.
How do you know what's in State's Exhibit 110?
It's a vest that he used to wear all the time.
Okay. And who is he?
Toby Madden.
Your dad?
Yes.
Okay. You've seen your dad wear that vest?
Yes.
Your Honor, I'd ask for permission ask for 110 to be admitted to permission.
Any objection, Mr. Wilder?
No objection.
All right, it'll be admitted and you may publish it.
Ms. Madden, we're almost done here. If you're looking at
Here.
State's Exhibit 110, what is it that we're looking at here?
We're looking at his vest that he wore quite often.
Okay. show defense counsel State's Exhibit 179. Are they approaching? Showing you what's marked as State's Exhibit 179. Who is depicted in State's Exhibit 179?
My mother, Rachelle Brewsaugh.
Okay. That's a picture of her at the morgue.
Yes, it is.
Other questions, Your Honor? Thank you.
Thank you. Okay, cross-examination, Mr. Wilder.
Good afternoon, Ms. Madden. Is it okay if I call you Michaela?
Yes.
All right. I'm going to ask you a few questions here. If you don't understand them or if they're confusing, just let me know and I'll try to rephrase them for you. Is that fair?
Yes.
I want to start with, you were questioned about something that your father said to you when he entered the courtroom today. When's the last time you saw your father?
Last time I saw him, I don't know, maybe in the earliest of October of 2022.
So it's been close to 2 years.
Yes.
And fair to say that in the last 2 years, you've not had the ability to see your
Yeah.
father. Is that fair?
Yes.
Were you emotional when you saw him today, like he was when he saw you?
Yeah, I would say so.
You talked about the Parish Avenue. We saw the picture. Isn't it true that you actually took your dad, Toby, to Parish?
I've never took Toby to Parish Avenue.
How many times do you think you were over at the Parish Avenue address? I think you said several times.
Yeah, several times.
And you were over there to check on the renovation?
I was there to pick up my daughter.
So you were just there to pick your daughter up? You
Quite a
weren't
few
there to
times,
check?
and I've seen the renovations too.
Okay. Correct me if I'm wrong, but that place on Parish was a mess when your mom first started trying to get that together?
I mean, it wasn't put together, but it wasn't super messy. She was an OCD lady.
Did you go into Parish Avenue address every time that you went there?
Most of the time, yeah.
And you would see a lot of tools, a lot of materials trying to get that house up to shape. Is that fair?
Yeah.
Were you?
Remodeling.
I'm sorry.
Remodeling.
Did you speak to the neighbors around your mom at all?
No. The ones in the blue house were weird.
You said the ones in the blue house were weird?
Yeah.
Did you see any people in that area that appeared to be under the influence of drugs when you went to Parish? Did you see people out and about that appeared to be?
No, not really.
Okay. Are you aware of whether the area around Parish Avenue, which is not only 5 minutes from this courthouse, is a drug area? Are you aware of that?
Yeah.
Did you notice the broken window on the Parish Avenue house?
Yes.
Were you aware that 5 days before your mom was murdered, there was a burglary at the house? Were you aware of that?
No.
When you went in the house, isn't it true that there were boards placed up in front of windows?
No.
There wasn't?
No, there was no boards placed up on the windows.
I noticed in the exhibit you were showing a picture of the house, there was a no trespassing sign. You saw that, correct?
Yeah, it's always been there.
Any indication why that's there?
The owner of the house before had it there.
And it's something that your mom kept up, correct?
Yeah.
Were you aware if people were getting in that house trespassing?
No.
How many entrances are there to that house?
There's the back door, and then there's the front door.
Okay. Is the backyard fenced in any way?
No.
So if someone were walking down the street and saw Parrish Avenue, they could walk to around the back of the house and...
On the sides there
back
was
door?
fences.
I'm sorry, what?
On the sides there was fences.
Okay, so you can't, unless you live there, you couldn't get into the backyard?
Mm-mm.
So you're saying it was gated off?
Well, the back part wasn't gated off, but both sides were fenced in.
Are you aware of anyone doing work to the back door in the few days before your mother was murdered?
No.
Now, you seem to insinuate or testify that Toby wasn't supposed to be at Parrish. Is that what you were trying to
I
tell us?
mean, no, he really wasn't, but he always comes. He's like a stray cat.
He's like a stray cat.
Yeah, he always follows.
Were you aware that her sister Sherry had asked Toby to come and assist with some of the renovation because someone named Casey Ward was not doing his job? Is that something you're aware of?
No.
Do you know who Casey Ward is?
Yes, I know who Casey
Were you
was.
aware he was being provided money to help with that house?
Yes.
But you're not aware that Toby was being asked to do stuff to help up
No.
help? That would be news to you
Yeah.
if you found that out.
Yeah.
When you went out to Parrish these several times, you said to pick up your daughter and you saw the residence. Did you ever see Toby there?
Yeah.
And was your mom Rachelle there as well?
Yes.
Did you see anything unusual between the two of them when you were out there at the house, Parrish?
Look like they always are in an argument, that's for sure.
And they've been together 27 years, is that right?
28.
28 years? Do you believe that Toby was trying to assist with the renovation at all of that house?
No.
You don't think
Sorry.
so?
No.
But fair to say that in even a few days before your mom was murdered, that Toby is around the house and your mom is renovating that house on Parrish, correct?
Yeah.
And Toby is still in her life.
Yeah.
When's the last time you spoke to your father? I asked you when the last time you saw him. When's the last time you spoke to him?
He contacted me not too long ago.
Over the phone?
Mm-hmm. I answered.
Did you ever observe your mother hit Toby?
No.
You never saw her strike him in any way? You did mention that Toby may have been upset or said something to the effect that your mom was cheating on him or was a prostitute. Is that what you said?
Yeah.
Is that something you heard with your own ears, or is that something that someone else told
No,
you?
I've heard it with my own ears.
Was your mom in the presence as well, or did he just
No.
tell you? Sorry, we kind of talked over it. When he said this to you, was it just you and him one-on-one?
Yes.
Your mom wasn't there?
Yes.
Did you ever know if your mom had ever hit your dad with a baseball bat or a bat of any kind?
No.
Have you ever taken your father to the hospital because of any injuries he may have received from your mother?
No.
Did you ever happen to see any video recording of incident where your mother had done something to you?
No.
Judge, that's all I have. Oh, one more thing.
Okay.
This podium was not as big as what I'm used to. I got a few more here. You know Colleen Shaw?
Yeah.
How long have you known her?
Since I was, let's see, 6th grade.
6th grade.
Yeah.
You know Tim Madden?
Yeah.
How do you know Tim Madden?
My uncle.
What about Bailey Shaw?
Yeah.
How do you know Bailey?
That's Colleen's son.
When's the last time you talked to Colleen?
Not too long ago.
To your knowledge, is Colleen a friend of Toby and Rachelle's?
Was my mom's friend, yeah.
Same thing with Bailey? Is he friends?
That's her son.
Would he be friends with Toby and Rachelle?
I guess you could say. Not really friends as a kid, you know.
Are you aware that Colleen Shaw used to hang out with your mom and dad? Is that
Yeah.
anything you know about? Did that happen a lot?
When we were younger, yeah. When I was younger.
To your knowledge, was Colleen Shaw hanging out with your mom and dad in let's say the month before she was murdered? Is that anything you know?
No.
Okay. Judge, that's all I have. Thank you.
Okay, thank you. Okay, redirect.
I don't believe I have any questions, Your Honor. Thank you. I would like to subject Ms. Madden to a recall, possibly any offense, please.
All right, very well. Okay, ma'am, I'm going to have you step down at this time, and as you heard Mr. Burris say, please be available in case you're needed for further testimony. Okay? Okay, so ladies and gentlemen, I'm going to go ahead and excuse you for the evening. I know it's been a long day, and again, I appreciate your patience with us. We will go a full day tomorrow, so I'd like you to be here promptly at 9 so we can get started. Again, I will give you a mid-morning break, mid-afternoon break, and we will have a lunch break as well. If you, again, need to let people know where you are, you're certainly welcome to do that, to give the court's phone number, but you may not talk about this case with anyone, and you may not do any kind of investigation, and you may not read anything about, watch anything about it that may be on the media or on the internet, okay? Please take those instructions very seriously, and I will see you tomorrow at 9 in the morning, okay? Okay, the jurors have been excused from the courtroom. Before we recess for the evening, is there anything on behalf of the state of Ohio?
So a couple of things. I do want to apologize. It was my intention to give out exhibit list to Mr. Wilder and the court before, so I apologize. There's obviously a few things that happened. Number two, I would assume the pathologist is not going to testify until at least Wednesday or Thursday, depending upon how witnesses are going to be slotted. I don't know if the court would like the photos we intend to use ahead of time. I'm sure if you have your computer, I can burn a PowerPoint onto a thumb drive for you so you can look at them, or if the court wants them ahead of time, or if the court just wants to deal with them at the time that the witness is called.
I think that I will need the context of testimony to make any decisions, but if there are particular photographs that you intend to use and that you have objections to those, Mr. Wilder, and it's something you want to take up prior to the testimony, we can do that, but I think I will be limited in any rulings I can make until I have the benefit of the testimony.
So if you have an external hard drive or a thumb drive, I can put the PowerPoint on it, however you like.
Typically, we go through it at the time, because like you said, Judge, it'll depend on the particular picture, and if there's one that I want to object to, we can just do it at that time. And maybe just make a general objection to where we don't, you need a sidebar, that's one thing, but if not, it may just be.
And the court doesn't let me show any photos until they're
Right. So I think we can just deal with it as it goes.
All right.
I think that's okay.
And then lastly, I didn't want the court to think I was misleading the court. I did ask for Michaela to be the victim representative. The court said, well, since she is the first witness, there's very little prejudice. However, I think some of the names that Mr. Wilder brought up in cross-examination and some of the questions may make her possibly a potential rebuttal witness in the state's case. So we can chew on that tonight and think about it tomorrow. But I know the court made its ruling thinking there's very little prejudice if she's going to be the first witness and she may not come back, and now that might change some things.
All right. And I would just note that she does have rights under Marcy's law. Those
Yes.
are constitutional rights, and she's essentially put on the same footing as the defendant. But if there are cases that you think that I need to be aware of, I would ask you to be prepared to argue those in the event that you wish for me to modify my ruling. Okay. Anything that you'd like to put on the record before we leave for the evening?
No, Judge, I'm good at this point.
Okay.
Thank you.
All right. I'll see everyone tomorrow
Thank you,
morning.
Judge.
We'll get started right at 9. Thank you.
Thank you. I assume I'll hold on to the photos that have been used.
Yes, please.